続きまして、インゴ・ベッケドルフ欧州特許庁審判部法律審判部門部門長です。
Thank you very much, and it's a pleasure to be back, and thank you very much for the nice photo that you showed earlier about our last seminar or last conference that we had 2 years ago. In order to stay in time, I will immediately move to the first slides on the actual situation at the Boards of Appeal, to the situation where what the Boards of Appeal are and what the role of the Boards of Appeal is. I will come later in my second presentation, so I will concentrate on figures first. What we had in the past 5 years, we set our own objectives to improve our work at the Boards of Appeal, the judicial work at the Boards of Appeal, and you may not be impressed by the numbers that you see, having heard both the Japanese and the Americans on this, but at least we are on the right track here. In the first 5 years, 2018 to 2023, we had 2 main objectives to which all colleagues in the Boards of Appeal, judges in the Boards of Appeal were really more or less obliged to fulfill. That was first bringing down the pendency time of proceedings, of appeal proceedings before the Boards of Appeal, and secondly, bringing down the number of pending appeals. The first objective, actually we achieved both of them. The first objective was to bring it down to 30 months, where we are in the next 5 years. I will show you on a different slide, and bringing down the number of pending cases. This was below 7,000, and actually in June 2024 we were down to 4,100 cases about, and the pendency time 30 months. The threshold there is to have no more than 10% being older, longer pending than 30 months, and we went down to a bit less than 10%. 10%. How did we achieve this? We achieved this by recruiting new judges, by improving the planning for cases in each board, by having a performance assessment, and part of the performance is in particular also settling cases, sticking to the objectives, fulfilling the objectives. We increase in our BDS, that is the business distribution scheme, which is important to decide to assign cases to the technical, in particular the technical Boards of Appeal. And here we have introduced some flexibility by being able to transfer files from one board, from one workloaded board to another board with a similar technical experience, qualification to deal with those cases. And we introduced a number of new provisions in our rules of procedure, one of which is that all boards are now obliged to issue a communication prior to oral proceedings. That is more or less at the end of the exchange of the written submissions by the parties, that the board shares with the parties its preliminary opinion. I will come to this at a later stage. And maybe one further point, the last point on this slide, we give a bit of an incentive to the parties to reconsider the probability and the chances of their appeals during the oral proceedings, in particular after having received the preliminary opinion of the board, to consider whether or not to maintain the appeal, to continue with the proceedings, or to withdraw. If they withdraw, they get 50% of their appeal fee reimbursed. So first, I already mentioned this, that we are down to less than 10% of the cases, pending cases, for more than 30 months. And I come now to I think the most relevant point, how we were able to achieve the 2 objectives so far. That is the communication. And communication means, I already mentioned it, that after the exchange of written submissions by the parties, or the party and ex parte, but parties in inter partes cases, that the board shares with the parties not only what the facts of the case are, to establish the facts of the case and to see whether the board has got it right or wrong. If wrong, not the best case, but nevertheless, then the parties can still make the board aware of that, but in particular to express a preliminary opinion on the outcome, potential outcome of the case. And this has led, and you see this on the slide, to increasing number of cases where the appeal is withdrawn after such a quality communication. The current workload situation. There we see a very important change over the past. If you see, what I consider here are the first 6 months of 2024, and I compare it with the same period in 2023. And what you see here, that the technical boards of appeal, there are altogether 25 technical boards of appeal, where the technical boards of appeal get less new cases, appeals from the divisions, administrative divisions of the office. It was last year it was 1,200. This year it's less than 900. This is 25% less. This is a lot. The enlarged board more or less stays stable, but the enlarged board does not take decisions on appeal cases. It takes only decisions on the interpretation of the European Patent Convention and on so-called petitions for review on procedural issues. The legal board of appeal was always low in numbers, but it went down also by a third. And the disciplinary board of appeal, this is a board that is not established under the European Patent Convention, but deals with disciplinary cases or disciplinary infringements by patent attorneys and or cases of candidates passing or not, rather not passing, failing to pass the European qualifying examination. This examination is the entry to be allowed to appear before the European Patent Office and before the boards of appeal. On the side of the settled cases, you see a more or less stable situation. It went down a bit as well, but it is not as dramatic as for the incoming cases. And if you look a bit closer to the different types of cases, you see that we had quite a change, in particular in exporter cases. Exporter cases are cases against refusals to grant a patent by the examining divisions of the office, and inter partes cases are cases on oppositions filed against granted patents. And if you look a bit closer to the three different fields, main fields that we cover in the boards of appeal, you see that in particular we have a low number of cases in the area of physics and electricity, and business methods and computer implemented invention belong to the last area. On the format of oral proceedings, I think we are almost all three, the Japanese, the US, and us, we are almost very close. It is that we have also about 60% of the cases being conducted by VICOM, by video conference, and some good 40% being done in person. Coming now to the new objectives. The new objectives is to bring down the pendency time for appeals to 24 months until 2025, end of 2025, and potentially even going below that in the years to come. We are now on good track because we see that the pendency time that we have in June was already below 30% of cases pending for more than 25 months. So I'm rather optimistic that we will reach this new threshold by the end of next year. I already mentioned that we learned from the first 5 years of having objectives that there are two important means to do this, and in particular in the rules of procedure, and we developed on these two important roles further. The first is the amendment of a particular article that is quite known, at least in Europe, as what we call the front loading of a case. What we expect from the parties is to submit their case, their complete case, at the outset of the appeal proceedings. If they do it only at a later stage, then they may run the risk of not being admitted, of submitting new requests, new objections, submitting new lines of arguments. And here we made it a bit more transparent to the parties that this threshold, or the hardest threshold to meet, to overcome, in order to get some new arguments, new objections, new requests into the proceedings, is with the preliminary opinion, with the communication by the board. This because then the case is more or less established from the factual side, and there should be no surprises unless there are very good reasons, exceptional circumstances, for a party to do so. And secondly, we are about to strengthen the value of the preliminary opinion under Article 15(1) of the Rules of Procedure, as being the decisive step in the procedure, so that the oral proceedings that come usually at the end, that these oral proceedings are only more or less a wrap-up of the entire proceedings. Coming to the enlarged board now, the enlarged board, I already explained to you what the enlarged board is about, and here we had a number of decisions in the past. I need to look up my slide here. Just a second, please. Here we had two major decisions in 2023, in the last year. There was the referral on G221, that was on what was called in the past plausibility. We still discussed this in Europe, but we stopped calling this plausibility, and now it concerns the question of reliance on a purported technical effect for inventive step, and for that the use of so-called post-published evidence. I'm not going to read out the entire decision because you can read it yourself, but the main topic here is that under certain circumstances, a party, in particular a patent proprietor or applicant, may rely on, in particular, test results which were done after the filing of the application. And this then can, under certain circumstances, be taken into consideration in the assessment of whether or not the claimed invention is really an inventive or not, or obvious, as it is called in other circumstances. And the second case was a combined case, G1 of 22 and G2 of 22, entitlement to priority, where we established that, first of all, the European Patent Office is allowed and it has an exclusive right to establish the right to priority, in particular with view of US cases where the right to priority sometimes is transferred from one party to the other party, and then there needs to be someone to decide whether this transfer is a valid one or no, and we decided that this can only be done in accordance with our law by the EPO. And secondly, to make it easier for applicants, that it's what we call a rebuttable presumption in favor of the party claiming to have a priority right transferred to him or herself. And then we have two pending cases. It's G1 of 2023. Here it concerns the issue of how to establish prior art. Again, I have no time, unfortunately, to go into detail, but this is something that it could be worth to look into it, and I expect to have a decision out in the next month. Let's say it this way. And lastly, G1 of 2024, just as a keyword, this concerns the interpretation of claim, the claim construction, and to what extent the patent specification needs to be taken into account, obligatory yes or no when interpreting a claim. Here we have just started our proceedings, so it's difficult to say when this case will be over, but I would expect, or we try to settle a case before the enlarged board within 12 months, 12 to 15 months. So that means that next year, at this point in time, the decision should be out. Quality is also, I will take 2 more minutes. Quality is also a very important issue at the boards of appeal. We try to foster the quality initiatives by having a number of working parties established with members and administrative staff in its composition, and the most important here is the quality-focused decision-making working party, which gives advice, not advice on a certain cases, but advice in general how to improve quality. We do have internal professional development events at the boards of appeal, and finally we do have regular meetings with other judiciaries and also with attorneys in Europe. I skip this slide now. Then we have our own publications. This is important, not only internally but also externally, and I will in particular refer to the first one, where we have the well-known case law book. The next edition will be published in summer next year, 11th edition, and also we publish on our website, on the epo.org webpage, we publish our abstracts of decisions, which give a bit more insight into recent case law. And finally, we issued a guidance on the use of artificial intelligence. This is a very new project that we introduced at the boards of appeal, and in order to summarize it, what we made clear to our colleagues, both administrative staff and judicial staff, is that they bear the responsibility of the correctness of all citations, of all use of external or internal tools. If they use AI-based tools, there are some internal ones at the EPO, but they may use also external ones, that they have to check. They have to check the reliability of the source, and they have also to check the result of this. And this is put down in a paper that will be soon distributed to all colleagues in order to allow them to make the best use of the modern developments that we have out there for the purposes of our judicial work. So with this, I stop now. Thank you very much.
ベッケドルフ部門長、ありがとうございました。